I want to thank Lisa for an opportunity to present as the part of Financial Planning Association member and director of Pro Bono department in the past. We worked with Saratoga Library many years to bring unbiased education to the surrounding community. And we have a long-standing relationship with Saratoga Library. It's been a great year for us to come back and present again in a new format via Zoom, and I'm really looking forward to share a lot of good information. There's many changes that happening in the state planning side. I'm happy to share with you. As Lisa stated, you can put your questions in the chat. I will not see them, and she can read it to me, and she will be able to interrupt me in between slides, and we can address those. If there is a longer answers required, I will address that toward the end. Presentation will last about 30-40 minutes, and then we'll leave plenty of time for Q&As. Again, my name is Larysa Prytula. I am a certified financial planner and also a certified divorce financial analyst. I have my own practice called ClearBridge Financial here in Campbell area, and I'm also actively working with Financial Planning Association on helping strengthen the fabric of the community by providing unbiased and up-to-date education to libraries, to youth, to a lot of organizations and nonprofit partners. Today we'll talk about estate planning. We'll start with first to identify a few housekeeping rules. Please mute yourself and also turn off your video. And in case you feel like there's a technical glitch, you may just dial in the number that was provided to you. Let's talk about the estate plan and what it takes to create one. In general, estate plan takes a collaboration between three different professionals. It's your financial planner, your advisor, who knows your personal situation, who knows what kind of potential planning you might need, your tax professional, and your estate attorney, who will be implementing the plan. The only person who can draft and make this plan legal is a licensed attorney in the state of California if you reside in the state of California. So nobody else really can create a legal document besides a practicing licensed attorney. What is your estate? Your estate is everything you own, starting from your house, rental properties, real estate, stock, bonds, bank accounts, your personal belongings, your IRA and other retirement accounts, your annuities. So anything you own is your estate. Not everything goes into your estate plan document, though. We'll talk about that. What needs to be under your trust name versus what needs to be outside of your trust name. We'll talk about it later. What your estate goals potentially can be. One of them is to transfer assets properly to your heirs. Another one could be if you're not in capacity, how you will be taken care of and how your estate will be taken care of. Ensure that your spouse is financially secure. So if one spouse dies, another spouse has an ability to sustain themselves financially. It also specifies the guardians for minor children. This is probably one of the most important reasons people create in trust when they have minor children. Business succession. It's hugely important for those who run their own business. And if it's a very small family business, is one of the business owner pass, you need to have a plan in place, how to replace that person, and also who will be taking care of all the logistics of the business. And giving to your charities. Estate planning options. If you have no plan in place, it's called intestacy via court probate proceedings. What that means is, if you don't have any estate plan, most likely your estate will end up in probate court to make decisions where the estate will go. And that's probably not the best option. We'll discuss why later on. Another option is to have a will or trust. Usually it's a living trust, it's revocable. Another option is assets to be funded through a beneficiary designation. IRAs, Roth IRAs, 401ks, they are not governed by the trust documents. Beneficiary designation supersede any of your trust and estate designations. It's very, very important to have your loved ones to be named as the beneficiaries of your account directly and not your trust, because then they have an option to distribute those assets in a manner that most appropriate to them based on their financial circumstances. So they have flexibility, where if it's given to your living trust and living trust doesn't have special arrangements for your IRAs, then it will be distributed in the same year you pass, which might create a lot of tax liabilities. If somebody is going through divorce or getting married, it's very important to review your beneficiary designation to make sure they're appropriate and current. One of the considerations we'll discuss today is the estate planning options of how do we avoid estate tax. And we'll talk about the tax exclusions and also what will be changing forward in those numbers. Let's talk about if you don't have a trust, what is going to happen. Once your assets exceed $166,000, it's in the state of California, other states might be a different number, you need an estate plan to avoid probate. So if the person has no real estate and the person has very little assets below 166,000, then they actually don't need a trust. It will avoid probate, it will be settled pretty easily and quickly, and assets will be distributed. Once you buy a property in California and once you exceed that amount, if you don't have a trust, then your assets will go to probate court, and you have to go through public proceedings, and it's expensive and very time-consuming. Give you an example that it will take about 1% of total estate value to probate your estate. So if your estate value by the time you die is $1 million, you have to pay $10,000 in estate preceding cost to administer your estate once you die. So it's not cheap, and it's a very lengthy process because there is hearing involved and probate attorneys that are assigned to the case.
Larysa?
Yes.
Somebody has a question. They asked, what about banks and investment account beneficiaries? Do they override the will and trust?
If that's a non-retirement account, and it doesn't matter if it's a bank account or investment account or any kind of account, they do not. So usually there is two ways to title your bank or investment accounts that outside of your retirement, IRA, 401k. Either you designate a TOD, transfer on death title, so which means if you pass, the bank knows where the money will go. So you can TOD it to a person. And actually that helps avoid probate because we know where the money needs to go. Other way, you can just make it joint with right of survivorship if you're married. And the third way, which is probably most comprehensive way, is to name it under the trust. If you don't have TOD designation or trust designation, that this asset, which is bank account or investment account, will most likely go through probate because we don't know where the money go unless there is a document in place that you can present and say this is what the decedent wanted to do with those accounts. So they do not supersede it. No.
Okay, thank you.
Probate court process, basically following the steps that usually are followed during a trust creation. They try to identify what was the will of the person who passed, how the assets will be divided between heirs. If there is any potential disputes, it's the time where, heirs might have a claim on the estate. There are sometimes heirs come that we didn't even know about them. So could be quite a surprise. Beneficiaries identified, so basically approved all the debts and claims that are paid. So that process that usually done by an estate attorney, if you have a trust, now become a public process, and it's done by an outside probate attorney. So that's where a lot of people are not comfortable to make all of this process public because anybody can come to court and listen to the administration of the estate. Few reasons to avoid probate. One, we talked about the cost, right? I said it's 1% and it gets more and more expensive. So it's expensive. There's a lot of delays. California probate courts are backed up right now. I had a case where my client had to make changes to his title on his property. It was not properly titled after his wife passed away. And we spent 6 months just going through the process with the state attorney, helping him to make a change, petition to the court, but courts were backed up. So his hearing took 4 months to schedule. So it's a very delayed process. You have no control over it, and obviously publicity of it. So not a good idea for those, especially who have a estate over, I would say, at least $500,000. What is revocable living trust? A revocable living trust is a legal entity. And by being a legal entity, when we pass, the legal entity doesn't. That's why a trust does not die. It stays valid and active after somebody passes away. So the trust is like a corporation. It continues to exist until terminated. You will fund your trust. Just creating a trust does not mean you're already done. And I see a lot of times, if your estate attorney some way did not follow up with you saying that you need to change the title of your bank accounts, investment accounts, house, and you didn't have a knowledge that that needs to be done in a timely manner, then you didn't fund the trust. And because you didn't fund the trust, the title stays the way they were originally. So even though you created a trust, it was not executed properly, so there is really no trust assets to deal with when person passes. We see it a lot. We see underfunding. We see not funding at all your trust. So creating a trust doesn't mean you're done. You need to change the title of your assets. Lisa, do we have any questions before I go? Doesn't look like it.
No, not right now.
Okay. So since the trust continues to exist after you die, the assets in the trust do not go through probate. When you die or become not in capacity, your co-trustee, or we call it also a successor trustee, depending. Sometimes it's only one trustee, sometimes there's 2 trustees, and there's husband and wife. If it's only one trustee, that trustee not in capacity, a successor trustee will come in and take over administration of the trust, meaning disbursements, making decisions of distributions for the wealth, for the benefit of the incapacitated trustee, and making all the administrative arrangements. The good news that even though you're funding your trust, meaning you're putting assets belongs to you into your trust, you become a grantor or trustor of the trust, you have full control. If it is a revocable trust, if you create an irrevocable trust, once you fund it, you no longer own those assets. There is reasons why some people create an irrevocable trust. We can talk about them separately, but in general, revocable trust allows you to have full control over the assets, also allows you to make changes during your lifetime and during your capacity where the assets will go. You can change it anytime for any reason. And upon your death, the successor trustee would step in and pay all your debts and distributions and disbursements that per trust documents. Let's talk about what assets needs to be transferred into the trust and which assets do not. In general, anything that does not belong to retirement accounts would need to go to a trust. Often clients ask me, do I need to put all of my bank accounts into the trust? It's a lot of work. I have 5 accounts. And I would say that most accounts will need to go to a trust. The ones that are in a very low balance, maybe below $20,000, $50,000, can stay under your name. But in reality, it would be ideal if every single account you own has a trust name on it. If you don't want to designate every account under the trust name, you can put TOD on some of the small bank accounts. Your major investment and major bank account should stay under your trust name. You need to be very careful how you title it. If you don't have a trust, there is few title options available to you: tenants in common, community property. In California, usually husband and wife would own assets as a community property with right of survivorship. unless those assets were acquired before marriage or were gifted to you during marriage, or you inherited them during marriage. So those are separate assets, and in general, you do not change the title on them, you keep them separate, because separate assets are not mingled with community assets and carry the same nature as they were created originally, which is the separate asset of that person. Your stocks, your bond accounts, your bank accounts, all of that needs to go into your trust name, and personal properties as well. I would not put a car under the trust name probably because it doesn't make sense, but you can definitely write in your will where this car or jewelry will go if you pass away. What's not transferred through the trust? Qualified retirement accounts, IRAs, SEP IRAs, 401ks. So it's very important to know that there's been a new law that was created, and not too many people paid attention because it was coincided with COVID. As of January 1st, 2020, we don't have a lifetime distribution options for inherited retirement assets. Previously, if spouse inherits, if the child inherits the property, IRA, 401k, retirement accounts, they can stretch the distribution over their own lifetime, which could be 30, 40 years for the child who is the age of 50. Between spouses, there was no difference. One spouse can inherit the other spouse IRA and can just stretch it over their lifetime. However, for anybody not a spouse, children, other heirs, you no longer have a lifetime to stretch those assets. The stretch option has been gone as of beginning of 2020. Now you have an options over 10-year distribution, which means that if it's $1 million IRA, now you have 10 years to deplete that account. And if you're already in a higher tax bracket and you have $1 million inherited IRA, you will need to take out at least $100,000 additional reportable taxable income on top of your current income to take the money out. So it's really not a good option. It's the way for a government to fund their budget deficit by taxing us faster and sooner on those inherited assets. So there is a ways to minimize the impact of this new law, and we can talk separately about it. But as of right now, that's the law, and definitely something to consider.
There's a question, Larysa. Somebody asked, can beneficiaries be outside the US, be non-American citizens?
Yes, they can. Yes, they can. However, the distributions of those assets will be happening in the US, on the US territory. Usually that person would need to establish some sort of beneficiary account, and those assets will be transferred to that person. Because it's not, so what's interesting about this situation is if that person doesn't have a residency status here in the United States, but now he or she is getting this big chunk of money from retirement accounts, they probably will need to establish at least tax ID number or social security number if applicable, and start filing tax returns, because now they'll have reportable income. I'm talking about IRA accounts. If it's a non-IRA accounts, it's a bit different.
Thank you.
Thank you. So we talked about that as well. So ensure current information on all life insurance policy, retirement accounts, and other investments. Why? Because life insurance is also another vehicle that requires beneficiary designation. And in general, we don't recommend the trust to be a beneficiary unless it's a very special trust, like irrevocable life insurance trust is the one where we want to name specific trust as the beneficiary. But in general, life insurance proceeds are distributed to whoever is the beneficiary, and those proceeds actually are not income tax, not subject to income taxes. right. Let's talk about the tax law that passed in 2018 that made your estate and gift tax exemption very high. Currently, the number is $11.4 million per person, which brings us to almost $23 million for couple. So right now, less than 1% of US population is subject to estate and gift tax, which is fantastic. However, it's not going to be that way long. By 2026, that new law that was passed in 2018 will sunset, and that estate and gift exemption goes down to $5 million. So if between husband and wife, both of the assets are over $10 million, $5 million for each person, then you will be subject to estate tax. And I'll explain how it works. Now let's talk about the new tax proposal that's looming over us, that's Biden administration is working on. So because we have such a huge budget deficit and we're trying to maintain economic growth, the Congress proposing a huge budget expansion. And because of that, they need to find a way to fund it. The easiest way to fund it is an increased taxes. And one of the few changes that come in, one of them that people who are making over $400,000, they will be paying 40 to 42% in the taxes. The brackets are going higher. One of them is a state tax. They're proposing to reduce estate and gift tax exemption to $3.5 million per person. Very big drop from 11.4, which means if the couple, husband and wife, have an estate over $7 million, which few people in Bay Area have, you will be subject to estate tax. And estate tax works this way: is, let's say by the time one spouse dies, there is no estate taxes due. And you also have something called portability. Portability rule is actually a very favorable rule where if estate of a deceased first spouse is below the current exclusion amount, we can port that unused amount toward a second spouse. After second spouse dies, his estate will have his exclusion plus unused exclusion from first spouse when he or she died. So that's actually a huge advantage. And when second spouse dies, estate taxes will be due. If estate is, let's say, $8 million by the time second spouse died, and at that time, Congress was successful passing a law saying that total exemption amount is only $7 million for two people, then you have, or they have rather, a taxable estate of 8 million minus 7, a $1 million. $1 million taxable estate will translate into 40% estate tax. And that will be $400,000 going to IRS within 9 months after second person dies. It's due upon 9 months of second death. Something to keep in mind: people who are subject to those estate taxes need to be very mindful to create a workable estate plan to minimize impact. It is likely you will not be able to avoid the estate tax once you go over the exemption amount. However, you can start actively gifting money. Let's talk about annual gift tax exemption. Annual gift tax exemption is a fantastic way of you start giving money to children, grandchildren, in small increments and taking those assets away from your estate. $15,000 per person per beneficiary means I can gift, if I have 2 children and 4 grandchildren, I can gift to 6 people $15,000 each. And that money will be out of my estate, and I also will not use up my lifetime exemption of $11 million. If I gift more than $15,000 per each person, I will have to file a Form 709, IRS form, telling IRS that I have gifted more than my annual gift exemption. And now my lifetime exclusion will be reduced by that amount. Any questions on that? Okay, so this chart or this slide depicts what I just said about new tax law. We don't know how it's going to look like yet. We just kind of have a blueprint of what potentially might be coming. And I believe if not $3.5 million, a lifetime exclusion, that's going to be a $5 million, but it's definitely going to be reduced significantly to fund the budget deficit. It's one of the easiest way to do it. Usually state gift taxes are taxed on a wealthier, so it's easier to pass, it's easier to collect. So just something to be prepared of. The rates that have been proposed is from 3.5 to 10, 45%. If you taxable estate over $10 million, 50, and then 55%. So it's very heavy tax. One of the biggest deal here is, let's say I want to gift some money. Let's say I own a corporation and my estate value is $20 million. I can give away $10 million today as a gift to my, say, grandchildren or children, and use this entire amount as my lifetime gift, right? New law says that you will not be able to do it anymore. You will have gift tax exemption for your entire lifetime as $1 million. So it's a huge deal, because now if my estate is $20 million and today my exclusion is 11, I better give it today, because tomorrow it goes dropping down to 5 or 3. So a lot of people who own companies, corporations, whose assets are very high up there, they start gifting very aggressively today, because if they don't, and the new law passes as of January 2022, then I only would be able to gift $1 million before I start to use up my exclusion amount. So it's huge change. It probably will affect a lot of people, because $1 million is not a lot of money if you want to gift it during your lifetime to folks who are in a higher net worth position. So they will increase the annual exclusion gift starting 2022 to $20,000. It's not a big jump from 15, but there is a jump. Gifting to avoid estate taxes. So we just talked about it. Very important to know, a lot of people who don't carry a residency status or citizenship status in this country, they do not have lifetime exclusion of $11 million or $5 million in the future, or 3, whatever the number. They have very low number. I believe it's 160,000, maybe 200. And the reason for that, because US government don't want the assets to leave United States before they tax it. So if you have a spouse who is not a resident, who doesn't have a green card or citizenship, you cannot pass on that money to them with your higher exclusion amount. You have to create a special trust to maneuver through that reality. So either the person need to become a US citizen or need to be a resident, but your exclusions are that person's exclusions are very, very low. One of the great strategies, instead of, let's say you want to gift a gift, but you don't want to go over $15,000, and you want to give to your grandchildren, which happens all the time, or your children, you can actually pay directly to the educational institution, to college, to university, the bill payments, and there is no limitations. So direct payments made to qualified domestic institution as a tuition payments for education avoids this $15,000 annual exclusion amount. Also, direct payments made payable to medical facilities on behalf of individual also do not limit your $15,000 gift exclusion. You can gift as much as you want through these payments, and they are not going to reduce your annual $15,000 gift exemption. Let's talk about basic estate plan documents. I will be very brief on it because I want to make sure I have your questions answered. There is a lot of parts to it. Trust estate plan has few documents. Now are all listed here. It's living trust, it's will, power of attorney for your property, advanced healthcare directives, who will be in charge of your healthcare decisions if you're not in capacity, HIPAA authorization forms, that's a release of private information, and general assignment of personal property. So basically it says if you're in capacity, how things will be handled, and if you're not in capacity, who will be handling financial and medical decisions on your behalf. Durable power of attorney gives someone you trust the power to take care of your property on your behalf if you become not in capacity. So durable power of attorney becomes effective only after the person is no longer in capacity. General power of attorney is opposite. It can be executed today when you're in capacity, but it ceases after you're not in capacity anymore. Healthcare directives is an important document that appoints a person you trust to make medical decisions on your behalf. So you need to find somebody who is caring, trusting, and available to help you with those things, should you need them. One of the biggest goals for estate plan is really to avoid the family discords, because if you don't have an estate plan, your family members really don't know how you want it to be handled, where you want the money to go. On top of all the expenses of public hearings, you also have this discord between your family members to really decide where the assets should be going. If you don't have an ability or time or for any other reasons to create a trust, then you should at least write a will. Write a will, make it witnessed by two people, preferably not family members, and then this will become valid. You don't need to notarize it. In the state of California, a witnessing will is enough, and you can basically write it by hand, or you can get a copy online. I also give clients a copy of a will that as a sample to look through. So that's one of the ways to avoid at least certain disturbance between family members on those decision making.
Larysa, somebody asked if you would describe the generation skipping tax. I don't know if you want to cover it now or later.
Sure, I can talk about that as well. So generation skipping tax was created for the purpose of that. Let's say I want to gift money, instead of giving it to children, I'm giving it to grandchildren. And was the idea was, well, I want to skip the generation and not, pay it to my kids, but the grandkids. Actually, in reality, it doesn't matter. The generation skipping tax is exactly the same thing as your estate tax. They just apply to you if the money are given to your, let's say, second or third generation. They ensure right now generation skipping tax is the same amount if you give tax exclusion, which also might change in the 2022. But it works exactly the same way. It's just a fancier way, a name for you to say, okay, I'm not giving money to kids, I'm giving to grandkids. Well, in that case, you're still subject to all the estate exclusion, all the estate law, and etc. So. When do you need an estate plan? As long as you become an adult. Once you become an adult, no one can make decisions on your behalf. And state of California is age of 18. So kids of age of 18 should have healthcare directives, financial power attorneys, and etc. Because at that time, you as a parent can no longer make decisions on their behalf, should they need your help.
Also, Larysa, somebody asks if the $15,000 annual gift exemption can be made in stocks instead of cash.
Absolutely. It's a great question because in general, I like the idea of gifting highly appreciated assets to someone. And the beauty of it, I do it all the time with my clients. I have a client that has stock. Instead of my client selling a stock, paying capital gain tax, and giving cash, we say, this is the great fund or stock that highly appreciated, why don't we give it to you, and probably will continue to appreciate, we give that stock or that mutual fund or that bond, it doesn't matter, we call it in kind, given the way it is today, to your beneficiaries or to your person who will be receiving a gift without selling it. And because you don't sell it, you don't have to pay capital gain tax. The person who receive it will assume, we call it donor's basis. The donor is person who donated or who gifted the money. So let's say if the grandchild or a child who was given that stock sells it, they will actually pay capital gain tax on the difference between at what price parent bought it and what price the child sold it. But it's going to be in their state, and if they're subject to lower taxes, they'll pay less tax than a parent. This just talks about, what happens if you have children, what needs to be done, what needs to be in your trust document. It's critically important to actually have a trust document once you have minor children, because your trust document will govern what will happen to your children. If you don't have it, and if you don't have a trust, then actually probate court or state of California, we call it, will decide where your child will be going and who will be taking care of your child. So it's you're losing complete control without having that stated in your trust documents. When you get married, it's critically important to create those documents as well, especially if it's a second marriage, there is a children prior to marriage. You need to create a document that will govern your new relationship. And if you don't, and you already have children from previous marriage, you potentially can disinherit those children. Not intentionally, but sometimes if you pass and you don't have a will or trust in place with the new relationship, then the children will start to making certain guesses how these assets will be distributed. And those assets could be your separate assets prior to marriage, your community assets. So it becomes a very, very messy process. So I encourage, especially second marriages, and we have a lot of those, please create a will, please create a trust, please talk about the prenup, do something that will help you build up the assets together, and also for your kids to benefit it without fighting with each other. So we came to the end of the presentation. I want to take a few questions here just to make sure that we don't have any unanswered questions, and also any comments.
Thank you so much, Larysa. If any of you have questions, please feel free to enter them in the chat box and I will ask them to Larysa. I do have a question, Larysa.
Absolutely.
I heard that this year people are able to donate from their IRAs. Is that correct? I guess basically they could use their, is there some kind of tax advantage to that?
It depends who you're donating to. So if you donate out of your IRA to a qualified charitable organization, let's say Saratoga Library is one of them, then you don't have to pay, you don't have to report that number as a taxable income. You still report it, but it's not taxed. If you donate out of the IRA account, let's say to an individual, then my understanding that it's still taxed. I have not heard that this avoids taxation.
And does that donation count as part of your RMD?
Yes, absolutely. It's a fantastic strategy. If you are at the age of 72, law, by the way, changed. It used to be 70 and a half. You have to take the RMDs in a year following. You reach age 70 and a half. Now it's 72, so it's pushed out. But yes, let's say you have $1 million IRA and your RMDs are $30,000. You really don't want to take the money out. You have other sources of income. You can donate partly, let's say $15,000, and give it to charities. And that $15,000 distribution is not going to be taxable.
Okay, all right, thank you. All right, there's a question. What supersedes, the living trust or the community property in California?
Great question. So first, I'm going to tell you, I have my best educated guess on it because I'm not an estate attorney. And the reason I'm saying that, because we just had a case where we thought that the trust will supersede it, but there was some agreements between husband and wife where actually the decision was made that community property with right of survivorship was supersede the trust. So I tell you, honestly, I don't know the answer. My understanding that it depends on the nature, how the account or asset was originally titled. If the account was originally titled under community property for right of survivorship, and then later on was changed to a trust, and by some reason the person was completely disinherited in that trust, then I think you have a case to say that it's been a community asset and it belongs to you. So the answer, it depends, and that's a great question to your state attorney, because it's very, very case specific.
Okay, thank you. All right, are there any other questions?
So,
well, it looks like there aren't any questions in the chat box.
okay.
So this, as I mentioned, this presentation has been recorded, and I'll let you know when it's been posted to our YouTube channel.
Thank you. I just wanted to mention something that if you're trying to do any end of the year tax planning, it's very important to address any estate gifting now, because if you don't and they change the exclusion amounts, it will not be available to you anymore. So updating your estate trust, talking to your state attorney, talk to your financial advisor is very important, because it will give you an ability to plan something what's coming, and it is coming. We just don't know what shape and form. We know taxes are going higher on the state side.
Okay, thank you so much, Larysa.
Yeah. Thank you.